Okay. Good evening. It's 6 o'clock, and I'm going to call the regular meeting of the City of Placerville Planning Commission to order. Will everyone join me in reciting the Pledge of Allegiance to the flag?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Mr. Painter, will you please call the roll?
Chair Keeney,
Present.
Vice Chair List, Member Friend,
Excitedly.
Member Lepper, Member Raines.
All right. On our consent calendar tonight, we have approval of our agenda and adoption of the regular meeting minutes. Does anyone from any of the commissioners want to discuss the consent calendar, or does anyone in the audience have a concern about the agenda?
Motion to adopt.
Okay, all in favor? Aye. Opposed? Okay, thank you. We move on to items of interest to the public. This is the portion of the meeting for members of the public wishing to address the Planning Commission on a matter that doesn't appear on tonight's agenda, but that's within our subject matter. Is there anyone in the audience who'd like to address the Commission at this time on something that's not on the agenda? All right. Mr. Painter or Mr. Rivas, are there any communications to share with the commissioners? No. Okay. All right. We'll move on to the focus of tonight, which is the workshop sessions. We have two, one on Ex Parte Communications and then on formula businesses. First, we'll do 8.1 Ex Parte Communications. I'm going to turn it over to our city attorney, Mr. Driscoll. It's a pleasure to have you here tonight, and thank you for being here.
Thank you, Madam Chair. It's my pleasure to be here. I very rarely get to come and visit you folks, so it's very nice to be able to be here and sit with you tonight for a little bit. The genesis, I think, of the interest in Ex Parte Communications probably goes to a recent event, and that was the appeal on one of the appeals on the sourdough application, where the issue of Ex Parte Communications was raised in the appeal documents. I think, and by the way, I'd like to keep this as informal as we can, so if you folks want to interrupt me and ask a question, please do so. Certainly there'll be some time afterwards if you have questions. And the presentation is not going to be that long. I don't want to bore you to death and legalize you to death, but it's going to be very similar to some of the materials I think that you've received. I know you received a handout some time ago from one of the planning journals, and then recently I think you received a handout, which is a paper from the League of California Cities on Ex Parte. And it's going to be very similar to that because basically the law is pretty simple. It's not real complicated. The first thing you have to do is what is an ex parte communication? And it's certainly a communication that takes place outside of the confines of the proceeding. In other words, you're having a hearing on a particular application. An ex parte communication could be something that was said to one of you either before or after the proceedings, assuming a final decision hadn't been rendered. So it's one that is outside of the formal proceedings, and it has to be substantive in nature and relevant to the merits of the proceeding or the application. So it's not just, hello, how are you? I understand you're hearing an application by John Doe to subdivide his property tonight. It's about it, but it's not substantive. There's nothing dealing with the merits of the application in that. Similarly, if someone were to say to you, I'm not in favor of that project, and that's all they say, that really doesn't give you any factual background towards the merits. So that would not be considered substantive. It's more like the applicant approaches you, I want to do this, this, and this in this project. What do you think of that? And then you start giving your opinion on that. Or you give input saying, oh, I think you ought to do it this way. Maybe instead of having this lot look like this lot should be configured differently or something like that. that becomes substantive and it talks about the merits. So those types of things are certainly considered ex parte communications. If you discuss the pros and cons of a particular project with an applicant or with somebody else, if you go into the merits of the project, you go into factual things, you're talking about something that could be an ex parte communication. Discussion with the applicant will generally get to that, so you have to be very careful if you're doing that. Discussion with your constituents may not. It may just be someone telling you, geez, I don't think you should vote in favor of that project. We don't like it. That's not going to cut it. And you don't really rise to the level of substantive. Barbara, I'm sorry.
Mic on, I'm having trouble
Oh,
hearing you.
okay. Well, I'll speak into it more. Okay? That's my fault, not the mine.
Thank you.
The other thing is that ex parte communications become an issue in certain types of proceedings, not so much when you're acting in a legislative capacity, but when you're acting in a quasi-judicial or adjudicatory capacity, which means adjudicatory hearings have certain things in common. There's usually advanced notice, there's a hearing, their decision is going to be based on some factual findings, and you apply existing law to certain facts. Examples would be variances, conditional or special use permits, site plan reviews. Those are all discretionary type things, but they're also adjudicatory in nature. So those situations are ones where you would be very careful of an ex parte communication. On the other hand, if you're doing a rezoning and you're not making necessarily findings, or you're dealing with amendments to zoning laws, those are more legislative in nature, and it would not necessarily apply in that situation. Are ex parte communications prohibited? No, not per se. Some agency, let me back up. The state of California has some regulations regarding ex parte communications depending on which agency of the state you're looking at. The Coastal Commission has certain rules. There's other administrative bodies within the state that have certain rules. Some prohibit them, some just have restrictions on them. Federal government, same thing. Many jurisdictions, and I know in your league handout there's a appendix to it which has rules from certain, like Riverside, I think there was various cities in there. So a lot of jurisdictions do have rules about them and policies, but not everybody, and there is no law that says you can't have an ex parte communication and still have a fair and impartial hearing. You can, but there's certain things you have to do if you're going to do that. And let me comment on the rules, because I know that you folks are considering the idea of maybe amending your bylaws or your policy regarding ex parte communications. You want to talk about that? My advice would be that any sort of regulation in a jurisdiction relating to ex parte communication should apply to everybody within that jurisdiction. Commissions, boards, and city councils. It should be the same for everyone. You don't want the council having one rule on ex parte communications and Planning Commission having another, the Rec and Parks Commission having a different one. It should be the same for everybody, which means it really needs to come down from the council. And not to say you can't provide suggestions to them. Obviously, they would welcome that, and it would be a good idea. But I think that's where it really has to come down in some sort of a proclamation from the council, or the council deciding how it's going to work. That's just my own opinion, but I think it makes a lot of sense. Another thing about ex parte communications, if you have, what is a no-no in an ex parte communication is to have one after the hearing has closed, but before the body has rendered a final decision. And I'll tell you why that is, because the way you can cure if there is a problem, or make sure that you have due process at a fair and impartial hearing, if you've had an ex parte communication before the hearing takes place, is to disclose that, and to disclose that early on, and disclose it in detail. Be very complete about it. That gives everybody, including the applicant, those people in the audience who have a position on it, the opportunity to comment on that and to either contest it or do other things to support their arguments, either in favor or against, because they know about it. If it happens after the hearing, nobody knows. And that fair and impartial analysis cannot take place. So the key is, if you have those discussions, and believe me, you're not the only people who have had this problem. I mean, I can remember when back in the 90s, when we had subdivisions that were coming forward. And a lot of times, the council or the planning commission would want to go out to the property and see it, and look at it, and see how it's going to be divided. You know, where are the roads going to go, where are the lots going to go, how many lots are there going to be, how congested or compact is it going to be, stuff like that. At one time, I think it was on the hotel project, everybody went out and we actually had a council meeting out there. So that wasn't an ex parte communication, because what was there was at a valid agendized, noticed public meeting. But it was not unusual for a developer to come to, let's say, a decision maker and saying, come on out, I want to show you what I've got here. And at that point, you have to be very careful. I find that the best advice is to listen and not say a lot. You know, if you have questions, you can ask them. But to me, your questions should really go to staff, because staff can then answer your questions or get the answers and put that information in the staff report so that everybody can see it when the hearing comes. Again, the idea is to give everybody an level playing field. Let's see. The best policy is probably to avoid them, because they do raise red flags, and you have to be very careful. And if you don't avoid them and you can't get out of it, don't comment, as I mentioned, on the merits of the project, or offer support. Or, you know, one of the things, there was a case where a commissioner went out, it was on a special use permit. A lady wanted to keep some tigers down in Ventura, and so she had to get a special use permit. And one of the commissioners went out and looked at the property and everything else, and had quite a conversation with her. The court found that that person, and they denied the use permit, but the court found that that person still had a fair and impartial hearing for two reasons. One, the commissioner did not say they were going to vote a certain way or make any promises to the individual. And secondly, they disclosed in great detail the entire communication and event that they had. So the court said we cannot find, based on that, we cannot find any basis for bias or the fact that the person was not fair and impartial on the hearing. Best practice, take your questions to staff, because they're going to provide you the best information. Anytime you talk to an applicant, they're going to probably color it to make their project look good, and discourage the contact with a third-party applicant, for example. But if you do have it, disclose it early, and disclose it early on in the process. I mean, the rules are fairly simple. That's really the best I can tell you at this point. So if you have questions about what I've said, or you think that didn't make sense, tell me.
Thank you very much. I don't have any specific questions. I think my concern about the ex parte issue particularly relates to the site visit. I found in, you know, my short time on the commission that going to the site actually can answer a lot of my questions. I think it's essential, and so I just wanted to make sure that we all were clear that you know, that is allowed. But your cautions against talking to the applicant, you know, it's hard to avoid the property owner,
Right.
especially something like a variance or easement or something like that, where it's their house, and you kind of need to let them know that you're on the property. But I hear your cautions against saying anything at that time. Just take information, and then in a timely manner disclosing to my other commissioners, to the public, so that this can be, you know, acknowledged, discussed, and we just have all the information out there. So thank you very much.
Well, and the courts recognize the value of a site visit, for example. They've discussed that in a number of the cases. And so, you know, I think it's just to tell the property owner you're there to see what it's all about, and that if they want to talk to you about it, it's best they talk to staff. If you have questions, you can ask them. But you're not there to do an evaluation of the project. You're not there to make a judgment on the merits of their project. You're there just to see what's going on. And that's a good thing. It's important. I think you do that, but you make it very clear. And then at the hearing, before the testimony starts, you disclose that and in detail what you did and what you was said.
Anyone else?
John, it's always good to see you, and you're always welcome at commission. The fact that we don't see you suggests that we aren't causing any problems. So, it strikes me that there's certainly after an application is filed, that strikes me as being somewhat of a different circumstance than when somebody has an idea and they want to talk to you. And I will tell you, and I mean, this is kind of giving me pause for concern. Not long ago, I was at a beer party. Actually, it was a wine party, but let's say it was a beer party, and I know lots of people and some friends, some folks there were planning to bring something to the city, and they talked to me about it. And I, frankly, I will tell you that I said, well, this and that and this and that. And so now you're saying that, that even if before there's an application or formal application, that if there were to subsequently be one, I should disclose that conversation, number one. And number two, you're also saying that really you probably shouldn't talk to them at that level.
Well, I think you're going to be a little stricter after the application's been filed.
So that's perfectly clear to
Now,
me.
at a social event, somebody comes up to you and says, geez, Mike, I'm thinking about developing this piece of property. What do you think? I would be very careful that you don't prejudge it. You may tell them things to do in terms of, well, go talk to Pierre or Andrew and find out what they're going to require for the property, that sort of thing. But you want to be very careful that you don't say things that indicate you've made a decision or you're prejudging it or you're in favor of it, because you're not getting the whole picture at that point.
Right.
So you have to be very careful in your comments. And so I think the way to couch your remarks is to say, you may have a good project there, but I'd have to see the whole thing. I can't tell you what to do with it much more than, go see our planning department. You may be on the right track, but I'd have to see the entire proposal before I could make a decision on that, and I can't do that at this time. I've got to do that in a public meeting.
Okay, and then just quickly, two other items. Just, I kind of categorize the legislative versus the quasi-judicial. One is actually fairly general and broad and overarching, and then the other one, that would be the legislative, and then the quasi-judicial seems to be specific to a project or application at hand. Is that a fair?
Correct. What you're doing is applying zoning, planning laws to a specific set of facts to determine whether or not a particular project, let's say, would qualify for a variance or a CUP.
Okay. And I'm kind of struggling with the scenario of when you would have an ex parte communication when it's been deliberated on but not decided. That's
Actually
a weird, that strikes me as kind of a weird.
Give me an example when that can happen. And we do this, not the ex parte communications afterwards, but we've done this procedure where we'll have an issue. It's come before yourselves or the council. The council has indicated, or you folks have indicated, you want to vote a certain way. And staff will say, okay, let us go back and make findings and bring those findings back to you so that you can approve the findings. We'll do formal findings. It's usually in a fairly sophisticated or complicated issue.
So that's
we'll
kind of
have
a
it.
continuance sort
So
of
the hearing
scenario.
isn't really closed, and somebody then goes to you folks and says, I don't like what you did last night, and this is why, boom, 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 boom. And so the hearing's closed. Nobody's getting an opportunity to evaluate that or to comment on that, and that's why you don't want any ex parte communications during that interim period after the hearing's closed. I suppose you could remedy it by reopening the hearing and saying, if that happened and you couldn't avoid it for some reason, you'd reopen the hearing and say, this is what happened, and I want people to know that so that they can address those issues.
And then lastly, in terms of full disclosure and documentation, and specific to the sourdough company in my situation, I had sent an email, right? I think to Mr. Bagley in this case. And so then he responded and I sent one back. So that's an ex parte communication. In terms of full disclosure, making that email available as part of the public record, I would assume would constitute full disclosure in addition to my stating it at the meeting, as I think I did. But if somebody wanted the record, and that seems to be, frankly to me, a better and more accurate way than a verbal. The verbal is kind of like, well, here's my summation of what we talked about, whereas the email is kind of a written, and it's very concise and digital. Boom, there it is, put it in the record sort of
I
thing.
agree. You notice one of the jurisdictions not only require disclosure, but they require you to make notes of your conversation and have that with you. So yes, I agree with you.
Thank you, Madam Chair. So
No,
sorry.
you're okay. Yeah, I thank you for that. That was really clarifying. I sort of went down a rabbit hole of reading about this stuff, and I did put together a draft of what I kind of thought was substantial points that I saw both repeated and strongly highlighted in amongst different cities and amongst different things. So I know I don't think we're making are we making recommendations to the city council today?
You folks can do that. You certainly can if you want to at some point in time. I don't know that that's the way your item is agendized, so you may have to, yeah, it's no action, so.
John, is council planning to come up with guidelines for all commissions and committees then?
I do not know that, Michael.
Okay.
They don't
Yeah.
currently have a policy of their.
I can answer that question. No, the council is not privy to this particular item that's being considered by the planning commission tonight, but just so you're aware, I have spoken with the city clerk, and she's very interested in addressing ex parte communication, so I will take, Amy, I'll take your language to her to maybe look at including it in your document. You should all have a document of City of Placerville Committee, Commission, and Board Policy Manual. And so this is probably the appropriate place where we would insert additional language regarding ex parte communication, because as Mr. Driscoll indicated earlier in his presentation, the city policy would apply to the council itself and all committees and commissions of the city.
Yeah, so, and this addresses one of your questions is of describing the pending application and clearly, and I thought that some of the language in some cities was really, really intense, and like you said, have to write it down and everything, and some were kind of really loose and wordy, and so I just took a stab at kind of combining, like I said, the one, so I'll leave a copy of that for you, but that was really clarifying, so thank you.
But it seems to me that whether an application has been filed or not, the decision tree we have to answer is, oh, if it's possible this might come before us, I should treat it as something that I want, it's pending or there's an application, right? I mean, even if it's a dream or a concept, I should just apply that standard to
You're
it.
going to be much better off if you do, because you'll avoid an appearance of bias or prejudice by doing so. You know, you don't want to have somebody saying, well, you had your mind made up at that social event 2 years ago.
Right.
So, yeah, I agree with you.
Have another Cabernet.
Okay, good, that's all I have.
John or Barbara, do you have any comments or any questions for?
What if you're in a semi-quasi-public meeting and you overhear two either commissioners or council people talking about an issue in this public meeting, and they're making derogatory remarks, which implies that their mind is made up? Are you supposed to report that to somebody?
No, you're under no obligation to. But if you feel compelled, you can certainly tell the person or the applicant or whoever it is that they are against, that they may want to question them and see if that's something that affects their ability to make a fair and impartial decision, or are they biased?
Okay, thank you.
Anything else at this time? Would you like to speak? Do you have any questions for Mr. Driscoll? Open it up to the public to- we'd like to
Because I appreciate you being here. First time, I guess,
comments to
about,
3 minutes, just as we do for regular sessions.
pardon? Wouldn't you know, I didn't bring my hearing aids and I didn't bring my glasses. What a great night. Want to repeat that, please?
I still want, I would like you to keep your comments, germane to the item.
Oh, they will be very germane. And I think that it's a little bit sometimes too vague. Very simply, ex parte, no. The staff put out an excellent article they distributed to the members about, I don't know, within the last year.
It was very clear that ex parte communication is not permitted, and explained why. Because when it comes to something that's substantive, how do we know it's substantive? Because we didn't hear it. So when somebody brings up something that's a dream or idea or concept that later could become a contested matter, the best answer is, this commission loves to hear from the public. Come on in and share your ideas. We may even calendar it in the future. But it's a real troublesome thing to do. That article also talked about other issues related to due process. And one of them is putting witnesses under oath. Most commissions, administrative bodies do, and they even allow for cross-examination. For example, back on Wilbur Howe's case, I can't tell you how many times that matter was up, and each time there'd be a commissioner who, before anybody spoke, would talk about Steve Calfee, what a wonderful guy he is, and how honored they are that he's here. Well, one of the issues that's always present is credibility of a witness when it comes to contested matters. So here you have a judgment being made about credibility before that was even brought in, and then there's no opportunity to raise it. And I've always thought that Steve, for all of his virtues, is very susceptible to impeachment. So I'm going to make a suggestion. Here's a suggestion. Rather than rely on one lawyer or another lawyer or another staff member, I'm going to give you a phone number, 530-752-6477. That's the dean of the UC Davis School of Law. Call him up, tell him who you are, tell him you're looking to look at bylaws, and you want some suggestions on how to write bylaws that are going to be consistent with the Constitution, and see if he's got a staff person.
I'm going to have to ask you to focus your comments to ex parte communications. That's what is.
Because you'll get, then you get what you,
aren't just,
well,
discussing
right now what you're
bylaws in
getting
general tonight.
reminds me of an old story about asking a lawyer, a mathematician, and an accountant what's 2 by 2 and 2.
Madam Chair, if I might, and Mr. Smith, respectfully, so this is a workshop, so it's a little bit more casual, and there's some give and take. So, but I'm going to say this as Commissioner Friend. First of all, the city has our legal counsel, and I clearly am going to follow the advice of legal counsel. And that's no disrespect to you. You made a statement, though, in your opening remarks. It was pretty limiting. It said ex parte, no. Okay.
Correct.
And so, and I heard clearly from legal that ex parte is absolutely permitted. I don't want to debate that per se, but again, let's take the scenario of there's an application for a variance because somebody's deck is going to extend, 2 feet over the line or over what it's supposed to be. So I'm going to go out to the property. I'm going to view the property. My presence there, if that individual, that applicant is there, by definition, that's ex parte. And I'm sure that you would not argue that I should be denied that opportunity to go out. And I think as legal even cited, that the court has said, oh yeah, that's absolutely legitimate and valuable. And I am going to go out and talk to them and say, please explain what you're planning to do. I think the crossing of the line is, if I understand this correctly, and correct me, John, if I start to say, oh, well, that's great, that's good, or oh, no, you need to fix this, or whatever, all I can really do is go out and tell them, I'm here to do an objective assessment of what you plan to do. They're allowed, I assume they're allowed to explain to me what they're planning to do and to walk me around. That's still ex parte. So I don't think it's entirely accurate to say blanket ex parte no. I don't think that's legitimate. I think good judgment suggests that, look, you cannot be prejudicial to the applicant for or against. I mean, you just have to be there objective to take in information. And then if somebody's coming to you, and particularly what's really tricky is this before there's actually an application. That's the thing that's really tripped me up a little bit. It's like, okay, because I'm a commissioner now, never thought of myself as that important, but now all of a sudden, okay, I am a commissioner, so if someone comes to me even before they file an application, I really have to be very careful. That perhaps is the most valuable thing to me that I've taken out of this, because beyond that, I didn't really have any question. I can understand what good judgment is. But do you follow what I'm saying? I don't think it's fair to say ex parte no. That would not be appropriate.
Well, I disagree with you. And the more common example of what you just described is when juries sometimes come out and look at a crime scene. And when they do, all members, both sides, court staff, are present. And so they're aware of what's said at that on-site review. Again, we can go on and on. I'll let a judge decide because there's still a chance to appeal it. I'm just trying to be helpful. And that's all. But the answer is, it's been addressed before.
You know, you advised us to educate ourselves about bylaws, and I'll just share with you that the document we've been discussing is from the League of California Cities. It's a tricky title, Let's Ex Parte. And this has really given me a lot of background information about the limits of ex parte communications and how they can be tricky. I think what Mr. Friend alluded to, we really do need to be cautious how we proceed as commissioners. And, you know, we appreciate your input and your perspective on this because there are legal implications for some of these actions. However, you know, John has made it very clear to us that it is absolutely allowed, but the important thing is to disclose it at the appropriate time so that both the applicant and the public are aware of that information and can refute it, discuss it in open forum.
To make it clear.
We appreciate, you know, our perspective on, to me, it's an information gathering tool.
To make it clear, I don't challenge the sincerity of any of you. I think you're all very smart people. I've enjoyed over the years watching you explain your positions, and you have a thankless job that I wouldn't want. When it comes to substantive matters of zoning, you and the staff know more than I will ever know, but on procedure, I differ strongly. And who wants to come up here and argue? I get paid to do the other forums. I'm trying to be helpful. And I think the only way to resolve it is frankly go to court. But there are other ways to do it. And I was suggesting, you can get free labor. Imagine a whole team of law students to draft up rules for you that you can reject or accept if you don't want to. And by the way, I appreciate you reading that article. I read about 7 of them from the League of California Cities before I filed my notice of appeal, just simply to read what was said in this state. So I'm glad you read it. Thank you.
Mr. Driscoll, if we had 5 lawyers, how many opinions might we get?
At least 4.5.
And just for the record, I mean, I want to thank Mr. Smith for the reason I think we're here, frankly, in all honesty, is because this issue was raised, and I believe you raised it. And this is educating me, so I appreciate that. That's helping the process. So that, I'll just say that, and I'll pass the microphone.
Yeah, just my question is from this California League of Cities, there is a statement saying, surprisingly, there is no California statutory law restricting ex parte communications with city decision makers at the state level. Just as you mentioned, the California Coastal Act, all of the other ones have forbidden ex parte communications, but not at the city level. Is that the case?
Yeah. Yes, that's true. And I think that Mr. Smith, in all due respect, I think he's well-intentioned, is mixing some apples and oranges when he starts talking about some of the federal issues, let's say. You've got different administrative law judges have different rules that apply to there. It's a different type of a hearing. Certainly a jury trial is something that is not the type of thing that would be compared to a hearing, let's say, in front of a planning commission. They're both important. They both want to make sure that the proceeding is fair and impartial, but there's different ways of going about it. And the rules that apply to jury trials don't necessarily apply to the rules that you have to live by. So.
And that's why it varies so much by city then as well, right?
And the article that you guys were handed, gosh, about a year or so ago, does not say that ex parte communications are verboten. In fact, it says basically, and I'll quote from it, the key to create a level playing field so that the applicant and appealing neighbors can address all information. Failure to properly disclose ex parte communications can lead to the board's decision being set aside. So again, it's a disclosure. It's giving everybody the opportunity to be heard. And in the example what Michael was giving, where he goes out and he's asking questions on the deck and whether it should be this size or that, and getting the information, he just discloses that. Now, if he tells the applicant, I think that maybe you should move your deck in a different direction, he needs to disclose that too.
But that's not forbidden.
It's not forbidden.
As long as I disclose that I offered a suggestion to the applicant to do this or that, then everything's above board, because I could just as easily make that suggestion in the public hearing, correct?
Correct.
And that's actually the nut of this, is that any information that happened as part of ex parte gets into the public discussion so that everybody essentially hears everything that happened.
Exactly. And to also be sure that you don't create the appearance of favoritism or bias as a result of that conversation.
Favoritism and bias, that's really, there it is right there. Okay.
And to work to avoid it, but if it happens.
My name is Dana LeBlanc. I'm a recent applicant for the Sourdough and Company, which was just recently approved, and wanted to speak to the whole process that I have gone through, seeing what happened in the community, seeing what happened on the boards, seeing what happened with your commission, seeing what happened with the city council, and then the ex parte part of that. Because ex parte probably applies to the public at some level as well, because you're having potential communications with those parties as stuff gets discussed around the street and in the town and in the paper. So I want to only speak to my experience through this whole process. What did I experience in coming to Placerville and trying to start a business? Who did I know? It was suggested to me early on in this process that I meet with the Placerville Downtown Association. That would be a good place to start introducing my project, talking about what I'm intending to do, which I did. And I went to that meeting, and out of that meeting, there were some city members that were there. I believe Mr. Cleve? He was there, and then some city council members, at least one city council member. And so after that meeting, I left, and I was on the street, and I ran into one of the city council members, just caught him for just a moment, and he really just kind of stopped me in my tracks and said, look, I'm not in a position to discuss anything around this. And I just want to say I really honor that he stood up, he took a stand, he knew what his ruling, what his limits were, and we had no discussion, and he walked off. And that's the honest truth of it. And I thought that's how it should happen, you know, having gone now through the process and heard the term ex parte and what that means and this discussion. So that's good. That tells you that the process worked when it needed to from a senior person on that council. So we don't know sometimes as citizens what these rules are. I come in, I don't know how the city works. I had to learn all of this process and the players and who does what. And so for me, it's kind of nice, actually, to see where it worked and where it didn't work. And in these meetings and in these council sessions and the Planning Commission, there were definitely some breakdowns here. And I think that I would just love to see these chairs filled with the people who fought this whole process. And where are they? You know, they're the ones who wanted these changes. They're these ones who wanted clarification, and I certainly do, because I went through the process. So I speak to that to say, I'm really pleased to see the city pull together and have this meeting and talk about it and form a workshop, and let's get some clarification around this because these issues arose. And so I thank you all for being here and, you know, volunteering your time and being a part of this process. Ex parte hopefully will be more clear for everybody.
I'd like to go back to my last conversation with Commissioner Friend for a minute, and the idea of suggesting certain things to the applicant. And I said you could do that. Yes, you can. But you have to be, as I said, be very, very careful, because what you're doing is creating the impression that if you do it this way, I'm in favor of your project. So I would really discourage that. If you have some ideas on a project that you think would make it better, the people to talk to are staff. Let them ferret it out and flesh it out and see if it works, and they can, if it's something there, they can put it in their staff report so it could be considered. But by telling the applicant that, you are potentially creating, at least in the mind of that applicant and anybody that would hear it, you might be in favor of that project, or you're going to be biased towards it now. So that's why I want to emphasize you really have to be careful and really try and restrict yourself to just getting information about the project.
That's fair, John. I guess, I think so. I can see this almost unavoidable in certain circumstances where you would get in the conversation and say that. But I would think if you then told the applicant, take these suggestions to staff and get their opinion on it, right? At the end of the day, I think you said it best. You're trying to avoid any appearance of favoritism or negative bias, right? At the end of the day, that's what you can do, not only to the applicant, but also to the public, right? So that seems, to me, I think that's going to be the rule that I follow.
Well, the other thing too, if you disclose these communications, as I indicated you need to, one of the things you have to be in a position to say, and say it honestly, is that none of these communications have influenced me for or against this project. They were information gathering only. And I'm able, even with respect to those communications, I'm still able to make a fair and impartial decision based upon what I hear tonight at this hearing. We've got some more fun stuff coming up, so I'm going to leave you. Thank you. It was a pleasure being here, meeting you.
I told John he could stick around for the next workshop. He turned me down.
I got a burger waiting at McDonald's. No, I'm kidding.
They can't hear that? Okay, we'll move on to item 8.2, formula business regulations and locations from our staff to discuss the current regulations and possible discussion of recommendations on modifications. I'll turn this over to Mr. Rivas.
Thank you, Madam Chair, members of the Planning Commission. Does everybody have a copy of the formula business regulation discussion outline? It's a one-page document. So what I'm going to do is I'm just going to go through the structure of this discussion outline, and then I'll go through all the various bullets through this document and try and, gender a good discussion of the different recommendations the staff is trying to solicit from the commission. So I'll start with an introduction, and then I'm going to go through talk a little bit about, just briefly, what the current regulations are regarding the regulation of formula business and central business zones. I'll talk a little bit about sourdough, just briefly. I think it's a really good case study now that it's behind us. And then I'll go into the options. And when you look at the options, like the very first option, for example, we took the same outline to the Placerville Economic Advisory Committee. We wanted to get their recommendations as well. And they stopped at the first bullet. So when they read the first option is no change, they felt that the current regulations were adequate and were responsive to looking at applications of a formula business that wants to locate within our central business district. That basically concluded the discussion. But if you are looking at change, well, then we have a number of different options to look at. The second bullet is increased formula business regulation. So we'll discuss, do we want to further regulate formula business? And that can be anything from a full ban to maybe trying to just pinpoint certain types of formula businesses for further regulation and exempting others. banks and real estate offices? Do we want to fully regulate those or ban those? And of course, the last bullet under that second bullet, other. So there may be other options that the commission has for staff to consider to bring to the council. And then that last bullet is the geographical area changes. And I put that on there mainly through what I heard to the whole sourdough application process. And that is that maybe if we look at modifications to further regulating a formula business, such as a full ban, maybe that's an area that's different than what you see on the map. So when you look at the map, we've got two maps up there. We've got a larger map if you're interested in looking at the aerial overlay, because you can get better sense of where you are geographically. But the other map, is which you all should have in front of you, is basically showing the extent of the central business district along Main Street. So there is some parcels that are taken in north and south of Main Street, but the most part is pretty linear, and it extends all the way from just west of where the KFC is, and then goes all the way up to Cedar Ravine and Main Street, and then it becomes more or less, I believe, Mr. Painter, correct me if I'm wrong, I think that's then you go from central business district zone to a commercial zone district. So unless you have any questions on how am I going to structure the discussion, I'm just going to start then up at the top. So looking up the top, current regulation. So the current regulation now is within the central business district zone, any formula business requires a conditional use permit and a site plan review. And that is always something that would then staff would bring forward to the Planning Commission for review and approval. And it's quasi-adjudicatory, as we just learned in our ex parte discussion. So I'll read that second bullet there under the current regulations. Formula business. What is a formula business? And we have it defined in our code. It's any business with a proposed or existing exterior design, which is appearance, colors, and signage, that is essentially identical to 5 or more business sites using the same or similar name or identity. And that's anywhere in the United States. It's not restricted to just within the city or just within the state of California. That's nationwide. I can give you some other examples of cities that have a little bit slightly different take on what a formula business is. For example, within the North Beach of the city of San Francisco, it's 11 or more. Essentially, it's the same definition, but 11 or more. Or you can look at something that's more restrictive, like the city of Carmel by the sea. It's 2 or more. And I spoke with the city planner for the city of Carmel, and she told me, well, she lives in Monterey. She told me there was a very, very popular restaurant in Monterey that wanted to open up another restaurant in Carmel, and Carmel made them go through a whole litany of changes to that restaurant so it wouldn't have any appearance that there's another one. They don't want any cookie cutters whatsoever. So that's very, very restrictive to the city of Placerville, which is 5 or more, to maybe something less restrictive in San Francisco. Yes?
When you say the 5, so I've heard this said, so if a place is called Spike's, and there's Spike's all across the nation, not one owner, but
Spike's Place in
let's
Goleta?
just say it's, yeah, sure, right. It's Spike's in Goleta, Spike's in wherever, Spike's, wherever. So that would then trigger the formula business, or no? Like, does it have to, the 5 are not under one owner specifically? It just is the name, or is it?
Right. Typically, what you're looking at is a formula business could be either, it could be owned by the company that could own the chain versus a license or a franchise. So McDonald's, for example, McDonald's, they have thousands of restaurants worldwide, and they're a franchise, and so they very strictly regulate the look, the menu, everything about that restaurant. Yes?
I would think at the end of the day, there has to be a business relationship of some type
That's my big question.
uniting them all together. Because let's say I go to Yuma and I open up a place, I just want to call it Spikes for whatever reason.
Right.
Has no relation to any of the other place. It's not the name itself. It really, at the end of the day, has to be the business affiliation and possibly the similarity with other Spikes. But I don't think it's just name only.
Right?
Yes, you are correct. So you have to have a number of elements that makes it the same restaurant, McDonald's. So I'm trying to think of a good example for from what you're saying. I can remember when I was traveling along the coast and I was in, what was the name of that? Gualala. And I went to a restaurant called Bones. And I had been going to this Bones that we have here in El Dorado County along Pleasant Valley Road. And I remember this gentleman that was seating us, he was about, I'm thinking 6'6", extremely tall, powerful looking man. And when I told him about Bones in El Dorado County, he came unglued and told me that they were infringing on their copyright, that they even came into the restaurant and wanted their menu to take with them so they could open up another store. So that's a situation that's a little bit kind of different. I think maybe that's more of a copyright issue, a civil matter between the two restaurants.
The law would be confusion in the marketplace, and I would suggest that Gualala and Pleasant Valley are sufficiently distinct and apart that there's no confusion in the marketplace. But if you've copied the menu, or if you've copied anything that wow, they look the same, you've replicated it, and that's trademark infringement.
But there was no business relationship. Like when I was very, very young, I worked at a McDonald's briefly, and that particular McDonald's I worked in was corporate owned. So we always had people coming into the restaurant with their brown ties that had the McDonald's logo on it. So, but anyways, I guess the point that I'm making is you can have something like sourdough, which started in El Dorado Hills and has grown to 20 plus stores. And I think our speaker that we had, Dana, he's not a franchise, but I understand he's a license, so he'll be the licensee. And there's probably he is using the name sourdough, using their menu, is going to have the similar quality of food and everything. And because of that, it qualifies as a formula business, as opposed to, say, the Bones wouldn't, or somebody that uses the name Spikes.
Okay.
It's not,
So even if there's more than 5 restaurants with that name, you wouldn't qualify as a formula.
Right,
Okay.
right,
Okay.
right. And I've seen that a few times where maybe a name of a particular business is not, it's not trademarked, and so other people can use it, as opposed to Starbucks or some of these others that are
The more
clearly
obvious, right.
either the same company or a franchise or a licensee. So very, very good question. Any other questions on that bullet? So we all know basically what a formula business is. So moving on to the central business zone, that's section 1514, formula business is permitted with a conditional use permit. And in a third business, site plan review is required. And it states new formula businesses and major exterior modifications to an existing formula business within the CBD zone. Major modifications are those defined. And so in other words, we could have a situation, say where the Shell station wants to, now that's a formula business. If it wanted to go through a major reformulation of their image, change the color of their building, their signage, they would go through a site plan review process in accordance to this section. And again, then we got to look at the purpose. So the conditional use permit allows the city to control the operation, and the site plan review allows the city to control how it looks, how it fits in with the neighborhood. We can look at the signage, we can look at the roof pitch and the building, the colors, all those kinds of things. And so if you had a vacant lot somewhere in our central business district, and say a big chain like McDonald's wanted to move in to a vacant lot on Main Street, we would have the ability to modify their architectural style so that you're not half a mile down the road and you can see what basically the whole building is a sign. We would be able to control the architecture so it fits in architecturally and historically with the surrounding buildings. And so that's what the purpose of the formula business does here in the city. So looking back to the Sourdough and Company application, a lot of people, came to me, members of the public, and they were astonished that the city allowed formula business within the central business district. They were trying to argue that it wasn't allowed. And I would, try to explain to them that formula business is allowed. It just has to go through a discretionary process, both the CUP, so we can look and visit its operation, make sure the operation isn't going to impact anything. McDonald's, for example, may want a drive-through. Well, that can really change the dynamics of the particular area if we were to allow a drive-through. And with the site plan review, then you can really modify the sign and the building, everything, so that it fits in architecturally and doesn't stick out like a beacon. So any questions?
So, city discretion then, and the signage and all of that. So, for example, I took a trip to the Sequoia Big Trees recently. I hate to say this, the first time as a native Californian I've been there, and it was just amazing, but drove Highway 49 to 41 and just the entire 49 route, and lots of small towns along the way. Sonora, I believe, a pizza factory right on the corner of Main Street, prominent, but architecturally it fit in. The only thing they had was their chevron, which is a little pizza guy, right? But I think it said Pizza Factory of Sonora. And there were several businesses, formula businesses, that said such and such of Sonora. And so, or of the town, Murphy's, for example. And so it gave a kind of a relationship, a sense of place, as Carolyn Ogden would always say, what's the sense of place? And a question then for staff, before I forget, I meant to ask John Driscoll, and please ask him, if I have a conversation with staff, is that ex parte on a project?
No.
Sure, okay, just thought about that. Okay, so if we had asked, could we have asked or required, and maybe you still can because I think it's at staff's level right now, the signage, could we have asked them to say Sourdough of Placerville, for example, or Main Street Sourdough, or something along those lines, just something to distinguish the business from the other businesses, number one, and number two, again, to give it that sense of place, to have it fit. Was that within our discretion to do that?
I think that discretion is probably somewhat limited. I will certainly disclose that staff has strongly recommended that the applicant do something a little bit different, add something to his signage, maybe have like a minor person or something of that nature to distinguish this particular sourdough of being, as you said, Sourdough of Placerville as opposed to sourdough on Missouri Flat or El Dorado Hills or all these other locations now where I now see them. It's interesting because I never even heard of the restaurant until they made application with the city.
Me too. Me too, exactly.
But I think we're very, very limited on telling an applicant how they can modify their trademark.
Carmel did it.
I don't think Carmel can change their trademark.
Okay. I mean, you suggested that Carmel made them do all kinds of things to distinguish that restaurant from the one in Monterey. And I would...
That was a formula business regulation. They want to distinguish that you come to Carmel, it is
unlike anything
absolutely
else.
unique, unlike any other town. This will be the only restaurant like it. And so that particular restaurant owner that had that successful restaurant in Monterey, and the name of that restaurant escapes me, but they would have to change that restaurant to the extent that it was distinguishable from the other restaurant in Monterey.
Right.
So if that makes sense. So if you recall on sourdough, I know there was a lot of discussion. Fortunately, staff did look at what was trademarked, and the city had a lot of discretion on how we could modify their sign. It didn't have to be a plastic, red glowing, internally illuminated sign, because really what was trademarked was the font, the lettering, and the Sourdough and Company, which was black and white. So we had a lot of discretion on the sign with sourdough. But if it was a McDonald's and they had their McDonald's symbol or whatever, you know, their sign is their sign. And I'll give you an example. I remember when I was in Madrid, Spain, and there was a McDonald's on downtown Madrid in an old building. We only knew it was a McDonald's because we saw their shingle hanging, and it was clear it was a McDonald's. They had their logo, so it wasn't like they were going to have to change their logo. But the sign itself, the size, how it was affixed to the building, all of that was in keeping with everything else on that area of the street.
We had examples of that come before this body years ago, and again, I think back when Carol Ann Ogden was on commission, I think it was specific to formula business, and again, sense of place, and how they can fit, right? And how they can be unique. And I'm not arguing for that by any stretch. I think when we get to the geographic piece, that might become even clearer, actually.
Yeah, we're probably getting into a discussion that's a little bit beyond what the purpose of this is, but I'll just give you a couple of quick examples. You know, I've seen the McDonald's in town of Mammoth Lakes. It's like a lodge. I haven't been in it, but I've seen the McDonald's in Sonora, Arizona, and it's a very Pueblo type of architecture. Really fits in with everything there that you see in Sonora, Arizona. So clearly, you know, a corporation like that will change their architecture to fit as the local ordinances in the city would like to see it. But it's their trademark sign. You could tell once you get a little closer. So in other words, I see the building from a distance. I can't tell it's a McDonald's until I can really see their sign. Their sign is of the appropriate size to everything else in that particular area.
Yet we were really restrictive with the Toyota dealership.
Right.
Now, that wasn't in the historic district, of course, but it was within the city. And we were pretty well told that we could not, they would not change their sign, period, case closed. And we kind of fell in line.
Well, Toyota said if you don't do this, you lose the franchise, right? I mean, that was.
Well, no, that was never implied.
I thought it was. I thought it was clear. I thought Mr. Thompson said that clearly.
I didn't think it was that clear.
Huh, I thought it was.
So I think with the case with Toyota, it does require site plan review, and so what staff and then the commission would look to for guidance is our development guide that sort of tries to, because that's a different sort of an area, very, very commercial, very highway oriented. That's highway commercial, which is much different than the central business district, where you're really looking at your neighbors, the sense, that sense of place, the cultural and historical look of that particular area, as opposed to the highway oriented auto dealership. So I think there's a little more leeway on how you want something to go. You wouldn't invoke that historic downtown in the highway commercial zone district.
And with our current procedure and rules, we do still have the ability to say, like, we could have told Sourdough and Co. if they weren't willing to change their sign, we could have just said no, correct, on the site plan review approval.
Yes,
And
that's
they would have
correct.
just been like, okay, well then we're out of luck on that part, if they weren't willing to change. Like, we don't
Yeah.
have to bend, I guess, is sort of what I'm trying to understand, is how far we would be potentially forced to bend if,
We can change as to lighting and texture and appearance.
okay,
But we could not modify, technically, we could not modify
The type.
sourdough, right? We couldn't say,
That's
you
correct.
must also include sourdough of Maine, for example, that
Yes.
trademark, their chevron.
but sort of a way in our current ones that we have that power is by saying, but it has to be XYZ material or look like we did with sourdough, and that kind of protects us
Right.
in that area, even so.
That's
yeah.
correct, and I think
Okay.
it's always important to keep in mind the context of where the business is locating. So I spoke to a lot of members of the public during that whole process. A lot of them didn't want a sign at all, or they wanted to tell the applicant that they should locate their sign on the south elevation as opposed to the east elevation. And then I would basically pose the question back to them is, you need to look at the other businesses on Main Street. You would be really constricting them far beyond how we regulate the other businesses, because there's a lot of signage on Main Street, and I think you need to afford a business owner the ability to advertise, as long as that advertisement isn't blatant and it's sticking out like a sore thumb, if
Agreed.
you will. Okay, let's see. So my last bullet there is just so you're aware, why are we here? It was the city council directed staff to return the council for possible modifications to the CBD zone regulations. And so they basically requested that we come to the Planning Commission to get recommendations from you on further restricting formula business. So it's not going to get into the conditional use permit component of it and the site plan review component, but basically restricting it like some of these other cities do. Do we wish to ban them? So I'm looking at now the options. So the first option is, would you mind calling like just a 3-minute recess?
Not at all. Well,
Great,
excuse me,
thank
I'm
you.
not the chairperson.
Of course.
Madam Chair?
We will recess until 7:10.
Yeah, thank you for the break. So under options now we're going to get into more of the fine grain. 3 basic options. No change. The current city regulations work well, and there's no reason to change them. And just a reminder, the city did change its ordinance back in 2004 to regulate formula business. In other words, requiring the CUP, requiring the site plan review for any formula business locating in the central business district. So if there's no change, I mean, we can certainly discuss it, but that would sort of end or shorten our discussion. So under increased formula business, I have 4 bullets there. So the first bullet is a complete ban. So in other words, you do have that the city has the ability to do a complete ban of any formula business within the central business zone district. So that would include banning any formula eating and drinking establishments, any retail stores or services, banks, real estate. We got a lot of formula businesses like Coldwell Banker, or all those are formula business. River City Bank, Eldorado Savings Banks, those are formula businesses. The second bullet is maybe a limited ban. So maybe, I'd like to ban formula business. We heard a lot of members. I mean, a lot of this I got from the public. I got a lot. So do we ban just eating and drinking establishments? And I say that is because that seemed to raise the ire of most of the public. They didn't want to see chain eating and drinking establishments on Main Street, but they were fine with River City Bank or other types of commercial businesses and retail. The third bullet, limited formula business ban to apply to only eating and drinking establishments. Okay, so that would be then something beyond that second bullet, to where you're only looking at banning that. And then maybe there's some other combination of something that I haven't thought of. And then we can get into the geographical area. And where that came up was because when staff brought up to certain members of the public, they were basically telling staff you shouldn't allow it at all in the central business district, and we would say, well, the central business district has allowed formula business in the past. We had Quiznos and Mr. Pickles, and we had a Starbucks. All those failed. But then the comment that at least I remember receiving quite a bit was that, well, that's not really the downtown core. The downtown core is just the area from Sacramento to Bedford, not from Sacramento all the way up to Cedar Ravine. So it excluded those areas. And so we bring that to the commission too, as you do have the ability, staff could easily fashion an ordinance that is geographically oriented, like an overlay, if you will, that would just state that you can only have a formula business within this particular area within the central business district. So with that, why don't we go back just to a general discussion on, do you wish to further ban formula business, and in what fashion?
Before we talk about the ban, When I come in off of Placerville Drive going east, there's a sign that says, "Welcome to historic downtown Placerville," or historic Placerville. So how does where's the historic overlay versus this central business district?
Thank you.
Good
That's
question.
that is the total disconnect for me in this entire conversation. And I don't mean to
Well, that's
stop.
okay. I don't care who answers the question.
No, I mean.
I don't know where it is.
I hear central business district, and I can just as easily see strip malls and a bunch of businesses that are nondescript as anything else. And I thought that the whole concern about this is preserving the unique historic character of Placerville. Yet there's no nexus that I can determine between that and CBD. And I'm going to go one step further, and maybe this comes under geographic. And I've told you this before. For some reason, I view that little square area where Sourdough is going in with the bell tower. That almost to me seems to be a highly sensitive, visible, historic area that, if anything else, I would carve out just that little area by itself. You got the stagecoach that goes there, and it's just iconic right there. But I don't mean to digress. I agree with you, Commissioner. I don't understand the historic component. It seems it's totally lost in all of this.
To me, well, my question around that and what you're saying is, what would be your idea of keeping or establishing the historic part of it? Because to me, we sort of preserved the historic nature of the building where Sourdough & Co. is going by implementing the no changing of the building, making the sign more that. So I guess my question is, I feel like we sort of did that. What would be the further step you would have taken beyond it being a formula business to make it historic?
Well, that's a great question, because
I hear that a lot. I can't wrap
if
my
a
brain.
McDonald's
Yeah.
or a Taco Bell or a Napa, and nothing wrong with those businesses, and wanted to come in there. We have Round Table Pizza here. It's been here forever. It's almost an icon in and of itself, but it doesn't necessarily have a historic component to it, right? Except the fact it's been here. But if any of those other businesses that wanted to go in where Sourdough is going in, I would have had a real problem with that. I would have said no, unless they were going to like totally do what some of the McDonald's have had. Even then, I think I would add a challenge with that. I think what kind of persuaded me in this case is I can totally see the nexus with Sourdough and as I said before, the mining history and the period. Those to me are in concert with each other. Not all businesses would enjoy that. So in some ways it's unique, but you can't craft regulation for the unique necessarily. It's really got to be applicable. So, but I appreciate you bringing up the historic piece, because I don't connect historic and CBD, and I don't know if staff has anything to add on that.
Yeah, staff can comment on that. That sign is sort of a brown color. That is a Caltrans sign that states Placerville, historic district.
No. Well, correct me if, are you talking about the big wooden one? Oh, welcome to historic old Hangtown or something?
Either way, it doesn't make any difference.
Okay.
When I come into town, there is an implication that this is historic Placerville. And I understand the central business district. My curiosity is, where is the historic zone or blocked off that might have different rules and regulations?
Okay, there is not. One does not
We
exist.
used to have a, when I researched the website, when I came on the commission, we used to have a historic committee that bellied up or folded, and those duties or requirements were transferred to the planning commission. Do we ever refer to those rules and regulations, or do we ever look, are there any historic mandates about any of our buildings?
Yeah, we're probably getting a little off topic,
Well,
but I'll try and answer your question then, and I'll
Okay.
let the chair then steer, but we can certainly go off. I can stay here all night. But anyways, the city has 4 historic districts. They're residential historic districts, and those items come to you quite a bit. Usually they're window changes or other changes, siding, that are modifications to a building, a house typically, within an historic district. That is a zoning overlay that adds additional regulations because it's in an historic area. So it allows then the city to apply conditions of approval on modifications to a building within these beyond the base zone, which is a residential zone. You can have a house, a garage, a pool, and that sort of thing.
But I submit to you, Pierre, that there's a presumption. If you just read the comments, what people were offering, there's a presumption that historic actually also applies to the CBD. I know legally, technically it does not, but there's a presumption that it does.
It does in a way, and I'll try and, let me see if I can explain that. It's not called an historic district. In fact, you know, you're probably aware that we're working through the pipeline. We're going to try and place an historic district overlay on historic downtown Main Street.
Yes. And that's
Which will allow the city greater discretion when people come in and they want to modify their buildings. So, but what we have here is, we have that map. That central business district is applied along that corridor of Main Street from basically just west of the KFC all the way up to Cedar Ravine. So if you recall, when the Highway 50 operational improvements were completed, the city rezoned a lot of those properties west of Sacramento from highway commercial to central business district.
Okay.
And so with that exercise, then following that, or just prior to that, the city also adopted that modification in 2004 to regulate formula business so that we wouldn't have additional formula businesses, fast food kind of stuff, like KFC, locating on a lot of those vacant parcels or redeveloping those underdeveloped parcels that are west of Sacramento or Spring Street.
So then let me ask this. With the historic overlay, what do you anticipate is going to be the relationship between the historic or the implication / impact of the historic overlay with the CBD?
Well, what's the exercise before you tonight? See, again, we're getting a little bit off topic, but this is to look
I'm
at
sorry for
regulation of formula
Right,
business.
I get it, but it's only
not other things.
Right, but here's my line of questioning, and here's why I think it's germane. Because I could see possibly in this development that you're doing that historic component would then have an impact on formula business in some of these options that you've given us. Do you follow what I'm saying?
I follow what you're saying, but again, the exercise of what we're trying to do is do we further regulate formula business? The historic district overlay will be different because that's going to affect all the non-formula businesses along Main Street.
But it could also affect formula business. It could also theoretically, and I'm not arguing for it, but theoretically it could also make it more restrictive, for example, for a formula business to be in the historic component of the CBD.
I would think that it would add an additional level of discretion on the city and the decision makers to further have something you can hang your hat on. Because remember, it's quasi adjudicatory, so you have to make findings. I think it allows the city a greater ability to further regulate the architecture of a formula business or any other use within the historic district, so that's in keeping with the historic district of the Main Street.
I think you could make findings for the bell tower area.
But I need to get back to Barbara and her question. So to answer your question, no, we do not have a regulatory zoning component to historic downtown Main Street. Everybody knows it's historic downtown Main Street, like almost every city has its historic district, where Broadway is not historic, Placerville Drive is not historic, but we have historic downtown Main Street. Caltrans recognizes it, they have that sign, we all know it is historic Main Street. So we have what it is in reality versus how we regulate
Right.
it and how it's
Marketed.
depicted on a zoning map.
That's marketed.
Does that make sense?
Yeah, to move along, I would like to request another meeting, a different day or time, where possibly we create a historic downtown business area, or at least, I don't understand how we can have 4 residential districts that are historic, but the heart and the soul of Placerville is not historic. So in order to move on tonight, because I've only got so much energy,
Yeah, it's not.
I would like to make a request that we bring this issue back at a different time and maybe create a historic district.
It's not necessary to do that because that process is already underway. We have a recommended downtown historic district overlay that will come to the Planning Commission hopefully sometime within the next 6 months, maybe. I looked at the city planner to answer that.
Who's involved in that project?
We are,
The 2 of you.
yeah.
Good.
So anyways, that, it's moving through the process, so you don't need to request it. It will come to you. It's in our general plan. The reason, I mean, it was a policy adopted in the city's general plan back in 1990. I think the reason why it has taken so long even to get consideration is because the opposition of a lot of the actual property owners do not want further regulation. But maybe the winds have changed, and I think from what I heard in Sourdough, a lot of the business owners want further protection of the downtown area. So hopefully they will embrace some additional regulation for that downtown area.
Maybe I can help to move this on a little bit. One of the questions came up, of course, I was not here during the Sourdough conversations, and talking to a number of people about that, the item came up, what's better, an empty storefront or a formula that we can work with? And I think we need to look at that very carefully, and my suggestion would be that we do not further regulate. I think that the formula that is here under current regulations has worked well. It gives us options, yet it does restrict in what could go in there. So I would not be in favor of changing.
I'll echo John. I went to the Placerville Economic Advisory Committee meeting and listened to their discussion. They had a lot of really interesting points that I agree. I hear a lot. You can't put a formula business down there without really understanding the long-term implications that might have, the limitations that might have, versus the regulation ability that we currently do have. Some of the points that I wrote down were that it's healthy to have a mix of the two. So not just having all mom and pop shops. One of the commissioners, I guess, of whatever, committee members, stated that sometimes it doesn't have to be a unique experience every time. It doesn't have to be something that really changes your life by that experience. It can be a mix of the two, of just getting something normal. There was concern that I thought was really interesting about hobby businesses, and sometimes restricting the kinds of businesses that can go in can create a thing where they gave an example that one couple, the husband opened an antique store, went on an RV trip for 6 weeks, and the shop was just closed. So now we've got a mom and pop shop, okay, but then it's not open, it's not creating any kind of commerce there, not producing money for the city. So I thought that was a really interesting point. Restricting property owners' right to rent to certain people, again, and the fact that our city, they stated, runs on sales tax, and during downturns and during different, if people are hard times, what are they going to do? You know, you're not going to not feed your family. You're going to have to figure out different things to do. So what I really took away from their conversation was that I think that if we have the power now to sort of regulate, we saw how it went with Sourdough. We put a lot of regulations on them. It was a several-month process with lots of different bodies overseeing it, looking at it, and coming to a thing, plus the public input, that these further limitations may have unintended consequences that would really could put us in a situation that would be a detriment to our city, rather than continuing to really be thoughtful, have our regulations as they are, and keep it so that we have the power, but it's not just automatic. And even when I was reading through, if we don't make a decision on a formula business, it's automatically denied, right? So it's not like there's this hidden power that people can kind of use to get around it. I felt like I read through, read through things just like I did before, and I feel it's sufficient. And so I'm with John that I think that the powers that are there are sufficient. I felt like I had control over the situation, and if they didn't like it, I did feel like we could be like, you got to play ball with us. So it's my opinion with John that we create no change.
I would support my fellow commissioners in their positions. I'm going to go backwards. Limit formula business ban to apply to only eating and drinking establishments, I find arbitrary. So I would never support that. Limit ban to apply to eating and drinking establishments and retail businesses, but exclude service businesses, arbitrary. Complete ban of all formula business, well, you had me at complete ban. I'd never support a complete ban. I think you lose so many opportunities that way. And so for that reason, I support the no change option. But again, I still have particular concern, and I think findings could absolutely be made for treating the bell tower area as a special and unique area where I think the city should absolutely have broader discretion in terms of what the businesses look like that go in there. And we've had all kinds of businesses come and go on Main Street. This is the first time, and I can't remember when, that we've had an issue, okay? So to me, that says what we're doing is fine, okay? And we shouldn't get all wrapped around the axle over one. Imagine the chair might want to say something at some point.
I certainly do. I really appreciate everyone else's comments. You really, I just have a few things to add. I think we're all seeing this and agreeing that our current system is working for Placerville. One thing, Mr. Friend, that you just brought up, being arbitrary. I did some research on our sister cities up and down the Golden Chain Highway, and also throughout California. And also I took a trip up to Ashland, Oregon. Was in their downtown, where they do have a couple. They have a Rocky Mountain Chocolates and a Starbucks right, within a stone's throw of the Shakespeare Theater, right there. So that they don't prohibit them. But these these things that you mentioned as being arbitrary, that's pretty much what other communities have done. And I agree with you that I think they are arbitrary. And I also just agree that I think that what we are doing is working. I don't want to be unfriendly toward businesses. That's a knock against a lot of the state, a lot of communities. We want to welcome businesses into all areas of Placerville. And I look back and I think back of what I read in our general plan, and we have a responsibility to offer services to a broad range. Yes, we're very concerned about protecting our historic district and protecting our local business people, but we need to consider and respect that there are other people who come through our town and they have other needs. They have other, and we shouldn't neglect that segment of the population. I think that we should look to our general plan. That's our guiding document. We want to have a diverse array of services, eateries, all sorts of businesses in our downtown. Or they keep on driving. So we have a couple of other formula businesses, and there's one thing that I just did this by accident. I found that the Vibes Up shop is a formula business. And I don't even know why that came to my attention. I guess just a Google search or something like that. But yeah, they've got more than 5, and that certainly was not controversial like sourdough.
Staff was told, sorry, Madam Chair, staff, I just want to interject. Staff was told that is the very first Vibes Up store is the one on Main Street, Placerville. I have not verified that, but I've heard that from several sources.
So working So we don't have a prohibition, so once you start on Main Street, Placerville, you can't.
If you
can't
become a,
a formula
if you
business
turn
or-
into a successful business and you franchise your business, we don't go back then and
Well, just like the Shell station, we
then
don't go
kick 'em
back and,
out.
well, you're a French.
If changes are made to an existing formula business, then the rules do apply to those changes, even though that business may have started here.
At the
You see
time
that
they,
it's-
they
yeah.
moved in, they were not
It's
a,
when they make exterior changes that are give,
it might come before.
it might come before.
Interesting, interesting. Oh, so you've already covered, we already have a caveat for that.
Third bullet that you're new formula businesses and major exterior modifications to existing formula businesses.
it happens a lot with filling stations.
They
Like
start
the Shell
one,
station, they
and then
will
they-
every periodically do a re-imaging of their business. I know I've seen one re-image to the KFC in the past, and then they recently, right, on Main Street, they're in the CBD zone, and they actually came in, and Andrew can speak with it in much more detail, but they actually came in with additional plans for a more recent re-imaging, and staff denied it on the onset because it was very bold. It was turning the whole building into a sign, and so we really wanted to do a lot of changes, and so they then pulled their application. They didn't move forward. They did make a couple of other changes, but nothing that triggered then a full site plan review.
Okay, and I also wanted to invite the members of the public, if you have any, comments that we haven't already brought up, feel free to bring that to our attention. This is a workshop, not a public hearing.
Well, again, my name is Dana. Thank you so much for taking some time to discuss it all together. Having been the sort of test case here recently for some of these changes and some of this discussion, it has been a real interesting experience for me and for the other people in the sourdough chain. But the beauty of that is we have a discussion. We are an open culture, we're an open society, and we have these opportunities to work things out. And that's more powerful than anything. Again, I wish the public was here to kind of set their views out there, because I'm hearing them through social media and I'm hearing through comments, and they can get distorted in their opinions and their thoughts. And boy, I'll tell you, I've spun for 4 months trying to read all this stuff and figure out the pulse of the community.
Even the press isn't here.
Even the press,
Even the press isn't here, frankly, which is.
Yeah, and the press has made a couple, 3 articles out there that, should be addressed and discussed, and it's open forum, and this is the perfect opportunity for everybody to be here. That's beside the point. I'm gonna say what I kind of am feeling and experiencing. You have to really figure this formula thing out, because I was very confused by what I was told and what was reality. I didn't learn until the city council meeting that the district is redefined another way. I always thought it was maybe a couple of blocks, because that's what I was reading and hearing. And then it was brought up by one of the city council members, the mayor, Kuna, that, well, it actually starts down there somewhere near KFC, and it goes all the way out to Cedar Ravine, I believe, street. So that's significantly different than the model I was being told. So that forms a whole different discussion around what the historic district is, what is historic. And there was a lot of argument about the history and definitions of history, and that's important. I like that. Several suggestions came out of all these discussions for us to look at, or for me, because really sourdough hears me. It isn't the other people. They're here to support what the city wants. And I think we're very clear from the beginning that we'll work with you. And I don't want to destroy anything here. I really don't, because I'm from here, And so I want ideas. And we modified the signage, and we submitted to council and staff. And it's still in discussion, but I think you'll see that we're very open to that. So it comes back to this idea of formula. So I don't think we need to limit formula. I think we need to define it and figure out the best ways to address it, because it's confusing at best. And that was all the discussion around the community. And I think the bigger arguments came from people pulling all the city documents for years and years and posting them up here and there and discussing this point and this point and this point. And, you know, there wasn't a lot of people to get around that message. And so that's for the city to kind of align and define and refine those discussions so that they don't come to this point. The more clarity we have out of this meeting and out of discussions, open discussions, the better that's going to be for everybody. It just limits the amount of arguments that can be brought before the city. It clarifies the issues around historic and non-historic, so because some of that will happen, as you're saying, over the next 6 months. The building itself, Mr. Friend mentioned the definition of that building. You're right, that's a critical building, and there's a lot of argument around how that's presented in the community because it is iconic and because there are pictures taken there. So we certainly don't want to have that feeling of suggesting McDonald's arches, major overpowering signage that just just destroys the feel of the community. So I think if we come to a discussion and a finalized signage, I think we'll all hopefully appreciate what we're able to come together on, you know. But that was the fear, and a lot of the discussion around this was all around fear. Quite a bit of it, not all of it, but a large percentage was, what is this going to mean to our town, Placerville, over time? And of course, you're city leaders, and you're developing the processes, and so there's room for discussion around that, and there's room for clarity around that, because we do want to have the sense of history. But it's that building, like it's like a 1950s Art Nouveau kind of look right now.
Yeah.
It's not really historic as I would perceive historic. And then I got into my thinking about, okay, all this discussion around it, what is historic? Does it start in the 1850s? Because there's a lot of history and pictures around that era from here. Does it start in the 1900s when a lot of things happened? I guess there were multiple fires in the community and rebuilds, and so there's no real clear definition of historic. And so we want it, but we can't define it. So that was hard for me to understand. What does this mean for me coming in, and how do I make it historic? All I really have to deal with, I guess, is the signage, because the building stays the same, and we'll do the inside, which is going to be very much in line with everything else in the city. So I just want to speak to it. I want the community, if this is out in the public, them to see, you know, there's an open discussion here, people. You have an opportunity, you know, let's try and make a difference together. Now, as far as other businesses that are here, we didn't talk about this, but if they already have a business and they want to form a formula business, now maybe they've been here for many years, any one of these could say, well, I'm going to add in a sponsor of some kind, you know, like a sourdough kind of thing where there's multiple opportunities, economies of scale, I can purchase more, you know, because these businesses have to compete in the real world. They have the Walmarts and the Amazons now taking over entire industries. We're seeing a paradigm shift like we've never seen in my whole lifetime. And we're going to see it in downtown Placerville. We just haven't seen it yet. But we're seeing bits of it, you know. So as a community, we need to come together and help this grow and stay strong and stop fighting and come together. So just want to throw all those things out. It's open for discussion. Thank you.
Thank you for your comments. I really appreciate that. I just wanted to add, before I forget, you reminded me that, you know, I really think we have a good business model for Sourdough and Company, and the public backlash against the Amazons, the big tilt-ups, the big chain stores. As I travel around, and I just think I've been lucky to find actually what turned out to be restaurants, businesses that met our definition of a formula business, but were actually very unique and offered something that, you know, you can't, isn't run-of-the-mill. And we need to appreciate that, you know, right now we've got a regulation, and we have I think we've all spoken that we're not in favor of changing it. Yes, we're protecting the historical nature, but we also don't want to impose something that's unreasonable for the next generation of entrepreneurs. as you mentioned, and let me just finish up, Kirk, I'll let you step up, but there's that advantage of the economies of scale to help a franchisee compete with an even larger formula or even larger chain. And so I am hesitant to impose more regulations that restrict our options to develop the downtown because, as in 20 or 30 years, there are going to be new people who come, and they have different needs. They'll have a different concept, and maybe what they will have is a formula business, but that offers a new array of services that we don't have, and they will have the leeway to fit into our historical downtown. And it's a moving target, and we need to respect what we have that is historical and protect that, but also look to the future and make sure that we're not imposing too much, so that we at some point don't have a vibrant downtown that has choices. And so I'll let you step up. You've been standing there quite some time. Please.
Thank you.
Go ahead.
Just in the name of full disclosure, I know the applicant is a good man. My family rented to him 30 years ago. I like him. He's an honorable man, and it's a good business. The comments have nothing to do with personal, has to do whether the application is consistent with the existing law. One of the primary concerns the public has had is whether you're going to be able to open this door, this slippery slope. What's next? A McDonald's downtown? Fish and chips, 8 Salt Esquire fish and chips, and so on. What Ms. Raines mentioned earlier before about an historic district, just to let you know, is not a new subject. It's been addressed by the city at least twice. And it's something that should be looked at before you abandon it and start off anew. The Historic Advisory Committee about 8 years ago found that it was appropriate to have an historic district downtown coupled with a body that would be responsible for administering the standards. And it said that according to studies, it shows that every time that happens, the property values go up and the sales tax revenue goes up. They also found that people who come here as visitors, accounting for a substantial part of our economic revenue, is people who come because of what's old, not new. Tourists come here because of those old features. So it doesn't mean compromise with those new things, because you can still have them on Broadway, Placerville Drive, etc. But this part of Main Street has intrinsic value. Secondly, the staff put on an excellent workshop in this very room maybe 6 years ago on that very subject. They brought in experts from all over the state, and people attended from all over the state, mostly Northern California. And they again concluded that study after study said that if you have an historic district downtown, what happens if it's coupled with an advisory body that administers regulations? Then you're going to have higher property values, and you're going to have increased sales tax revenues. Now, I don't know if the presentation by my distinguished colleague, who I've known for a great many years, went very far, because he's talked about the perils of making conclusions before you've had a chance to consider everything. Mr. Lent, I know of a number of businesses that sought to have that same property, including a bakery and things of that kind. So to suggest that if it was either that or be vacant, there's no support for it. And nobody ever went into it. There's nothing in the record to support that. Likewise, I've heard people...
Mr. Schnitz, can you bring your comments back to, this workshop is focused on the formula businesses in our central business district, and Pierre has already mentioned that, that the idea of putting the historical business or historical overlay is something that staff's working on, and it's going to come to us and we can discuss that. But right now we are talking about whether we should further regulate formula businesses in the central business district. So I'd like you to bring your comments back.
Well,
it's getting late
and I believe
in the
that
day,
there...
but I'd like to know what you think about what we have, our current regulation, or if you have a suggestion on how we can improve our regulation of formula businesses.
Yes, and the two are parallel because actually.
They are parallel, but we've talked about this, we've had this workshop going now for, some time.
The
and
primary
I'd like to hear what you
thrust
think about
of
the formula
having-
business.
Yeah, the primary thrust of having this is to be able to preserve the historic character of Main Street. And if you open the door, you're not going to get it forward. Now, one of the factors that was suggested is, do you limit it, and if so, geographically? From Sacramento Street west, you actually have only 3 historic structures. One is a 1903 railroad crossing trestle. You have the Elder Options Building, which was Forney Road. Forney Road was a toll house.
So
a
your
toll road.
suggestion then would be to,
So I'm suggesting.
how would we change the formula business regulation to, satisfy this concern you've got about the historic buildings there?
My personal preference is that you include as far as the 1903. Practical matter, I don't think you're going to get it, and the reason is because I've heard it said that contractors oppose it. The only one I know of who ever publicly opposed
Opposed the,
having the historic standards.
okay, but we're talking again
Which
about the
includes
current
formula
regulation or whether
and,
we can
yeah,
improve
formula
our
businesses,
regulations on
all
formula
that stuff.
businesses.
Because the only one who objected was Judy Putoff, Wendy Thomas's mother, when it came to the Jack Russell Brewery. And for those of you who were here, that was interesting to take a look at. It deserves to be looked at. I think politically, you're going to have a hard time getting it west of Sacramento Street for that reason. But it should be adopted. You should have those rules now. They should have been clear before, but you definitely need them
But you're
because
talking about historical district. You're not talking about the formula.
the formula rule
So do you have,
should be
what
strictly
I'm trying to
enforced.
get, I appreciate your, respect and how we need, your concern for the historic district, but what we're looking at tonight is, is our current regulation solid and strong enough? And, I think the commissioners and also the Economic Advisory Committee, we're all saying that, what we have works. And do you, what's your opinion about our formula business regulation? And do you have a suggestion for a way to improve the formula
should-
business,
they should be
conditional use permit
restrictive.
and site plan review process?
They should be restrictive to have not allowed for sourdough in the first place, but it should be restrictive in that area from Sacramento Street to Cedar Ravine. I don't know how I can make it any more clear than that. And by the way, I think that you run the planning commission, not the staff. So if you want to have a workshop on the, on an historic district, there's nothing to stop you from doing it now and doing it later and doing it all kinds of times. But it's an important subject. But
Yeah, Madam Chair, if I may, just for clarification, let's just say we had an historic district in place, it wouldn't restrict formula business. They would still be allowed under a CUP and a site plan review. It just places a greater emphasis on the historic character, but you already have that discretion because under the CUP and site plan review, you can modify the application so that you feel, as you feel fit, it fits in with the area. If you're looking at formula business going to locate next to KFC, well, you're probably going to be impose less of modifications to an application than you would, say, at the sourdough location.
it's
The
site
applicant
specific.
made no changes to the building. There was nothing to change.
I think that's-
Anyways, I hope that's helpful.
Pierre, to me, this is a very subtle but important point, however, because I would think that if we had a historic district overlay, that would suggest increased discretion,
I think I said that.
which also kind of translates in my mind to limitation. And so we have more control, more arbitrary judgment that we can apply, because we can say, well, this is a historic district, and so my standard then, as a commissioner, is now over here, whereas for a general CBD, it's over here. Am I understanding this correctly?
No, I think staff would disagree with that. I'm getting the sense that what you're saying is you would have then the ability to deny a formula business because it's a formula business, and I would disagree.
No,
with that.
okay, so no, I'm not saying that, but my requirement of what I could ask the formula business to do now starts to gravitate somewhat more towards what you suggested Carmel maybe did. Changes, compelling changes on the.
Staff
right?
would disagree with that. I mean, I spoke with the city of Carmel, and you can pull up the city of Carmel zoning code that has the purpose statements, why they impose a limitation. It's because, and this is what I heard from the public, this is why members of the public disagreed with sourdough being a formula business, is because, and this is what I was told, we have visitors come to Placerville for the uniqueness of Main Street. And so they don't want to go to a cookie cutter chain restaurant. They want to go to a mom and pop where it's found nowhere else. And we have that discretion. That's why this is before you. It's for further limiting formula business. Now, the Economic Advisory Committee felt that was the wrong course of action. You know, staff is here to facilitate that discussion, not really to push you in any direction.
No, I get it. I'm trying to parse the terms, and I don't want to prolong the discussion, because I think hopefully when the historic component, it will come to us, and maybe we can again have the discussion about what that might mean in terms of commission's discretion and council's discretion. It means a little bit different to me. To me, if you have a historic district overlay in the CBD, to me that suggests a different standard.
Like what?
In terms of appearance, it's a different standard in terms of what I can say. Here's treatments I want you to. Here's treatments I want. I want it to fit in with a historic district, as opposed to a central business district, which I find to be much more generic.
Well, I wouldn't want them to
Staff would
be,
agree, but that's
more
not what's
onerous.
before you. We will bring the historic district proposals to you, and if you wish, you can certainly look at your zoning codes that you have, and you can look at the historic district requirements under the site plan review section. And of course, we modified, and Andrew, you probably recall, we modified the development guide to give greater direction on how you review projects that are in an historic district and what kind of architecture you want to see. We added that, if you remember. You were on the commission then.
Right, and I'm kind of saying the same thing, but I just plan to
But
filibuster
that's a little
the
bit
whole thing anyway.
separate than formula business. We came here really to seek out whether there was desire with the city to restrict them like these other cities do. And obviously, I'm not hearing that from the commission.
I think that hasn't changed.
I'd just like to finish my thought, which was the Planning Commission and city staff. We have the power to and the authority to change the look through our site plan review process. I think the difference if we get this historic district overlay, it will be site specific. You know, we've talked about that quite a bit this evening, and that's why a site visit is very important. My view of a certain part of the central business district down by KFC, you're right. I think I would hold that to a different standard. I would want it to fit in. I wouldn't want it to be, or wouldn't force it to be particularly old-timey because we're in one area of the CBD versus another. I'd want it to fit in, as is proper. And as we get, in another part of Main Street, that's what we did with sourdough. We said this, that bright red sign does not look the way we want it to there by the bell tower, we had the authority and to make those changes. So
Well, first of all, so if there is no historic district and we only have certain rules and regulations, I guess there's no requirements going to be put on the ketchup mustard building with the remodeling because it's not historic enough to mandate. I would like a workshop on historic buildings. I don't know whether Mr. Leblanc is it, who has been so patient and so kind. I'm not sure he would have half the hassle if he hadn't chosen the oldest building in downtown Placerville outside of the Tallman Museum to put his business in. So that's all. Thank you.
I'm a curmudgeon, I want old-timey.
Well, I think what frustrates me too is that I hear that there are certain groups of people in whatever capacity speaking on behalf of the city prior to businesses exploring the city. And that bothers me because we have people who are appointed, we have people who are elected to look at how the city should be going, spend a lot of time, money, effort, whatever, research, looking at that, analyzing it, going for the best. I don't feel like anyone on any commission that I've seen is sitting here like, how can I destroy Placerville, you know? And so it bothers me that there's so many people speaking for the city as well. And I just want to make that statement in general that frustrated me in this process, and I think it misconstrues a lot of information and also presents itself as a body of the city. And I don't know what the capacity is of the different, you know, the Placerville Downtown Association or the whatever, Friends of Historic, different things like that. All the different groups that came up in this, at least to me, frustrated me because I think that there's a method and there's guidelines and there are ordinances and things that should speak for the city and rather than individuals who want to represent themselves that way. So that's just my thought process on that.
Madam Chair, staff
yes.
would request that you take a poll vote or just a general on which of these proposals. If it's the first bullet, no change, we could get.
Are you suggesting a roll call or just an up or down?
Can we just do an up or down, Andrew? Do you want a roll call? What do you prefer?
If I may, through the chair, so our role here is to send an advisory or recommendation to.
We will take this recommendation
So
to the council.
we need to take action?
Let's go ahead and, yeah, I'd like something, a general,
Okay.
or general consensus
Just
is
general,
probably
let's just
good
make
enough. You're all in favor?
I think general
Unanimously in
consensus-
favor of no change under the,
Yeah, I think
keep
so,
the
no
existing
changes.
regs.
I'll make a motion that the general consensus of the commission is no change in the existing formula business regulations.
Yes, I think we're all, is anyone opposed to that? That would be our recommendation for no
Great.
change.
Thank you very much.
That was part of the motion. We recommend it.
All right, well, we do have no public hearings, but new business, 10.1 is a review and a possible amendment to the Planning Commission bylaws. Given what we've, actually, I want to be clear, Mr. Painter, is that about the ex parte communication change to the bylaws? Is that why that's on our agenda tonight?
That was per your request a few weeks back.
Okay, regarding ex parte communications.
I don't remember the context, but
Okay.
that sounds like that was why, yeah.
Okay, so this item that I placed on our agenda, given what we've learned tonight about, in general, the bylaws and the possibility that the city council may be considering it, and also John Driscoll's advice that we make this consistent across all city entities, I would like to withdraw that discussion unless one of my other commissioners would like to bring it up for a vote.
I was
Or
going to move we
discussion.
suspend the bylaws in perpetuity. But I'm not going to.
Well, it's.
Yeah, technically, the
Okay.
bylaws are codified in code that the planning commission must have them, so, yeah.
Well, we can still suspend them, they're there.
You could still suspend them, yeah.
Okay, moving on to item
You
11.
could make the claim that you like the color green. If that's really what you wanted to put in your bylaws, I suppose that's what you could do.
Are there other matters from commissioners for the staff to consider? And staff, do you have anything else to bring to our attention at this time?
The only thing that I have is, well, actually, two things. We will have an agenda 2 weeks from today. There will be a public hearing item. Also, per the request by Member Raines, I have made copies of the resolution that created the Historical Advisory Committee and the resolution by City Council to, I want to use the right words here, they disbanded, that's not the right word they used, but they reassigned the duties to the Planning Commission, which is what Member Raines was discussing. So I think all of you have this, but I do have copies for each of you if you want.
Okay, thank you very much.
Yeah, typically we provide these to you when you become a member, so you might have them in your, some people got boxes, some people got, yeah, all right. So please pick one up as you leave.
Thank you. All right, well, it's 8:04, and at this time, we'll adjourn the Planning Commission until our next meeting on October 15th at 6 p.m. Thank you very much, everyone.